Virginia employers, if you are still relying on your 2024 or 2025 drug testing policy in February 2026, you may already be exposed to a wrongful termination claim. On paper, nothing dramatic happened overnight. But in practice, well, this is where the shift begins. Because under current Virginia law, an employee can test positive for cannabis, and that alone may no longer justify termination in many roles. That sounds simple. It isn't. And by the end of this video, you'll see exactly why a policy that once protected your business could now create liability instead. Here's the counterintuitive legal fact. Here's the part that surprises employers. Virginia recreational cannabis legalization did not eliminate employer rights. But it did limit how those rights can be exercised. Legally, employers still have authority to maintain a drug-free workplace. That is accurate. Yet operationally misleading. Because a positive test for cannabis metabolites does not necessarily prove impairment while on duty, and that distinction is now where cases turn. Most businesses think, if it's in the system, it violates policy. But that assumption no longer holds the same weight it once did. And this is where confusion begins. Let's challenge a belief. Many employers believe they can simply say, "We prohibit cannabis use." Well, you can prohibit on-duty impairment. You can enforce safety rules. You can discipline intoxication at work. But disciplining off-duty legal consumption, based solely on a metabolite test, may now conflict with Virginia employment protections depending on the role. And this is where the enforcement question starts to matter. Not what the handbook says. Not what the lab report says. But how Virginia courts interpret adverse action tied to lawful off-duty conduct. We'll return to that. Welcome to Norfolk, Virginia Cannabis Hub, where we focus on Virginia-specific cannabis law, local governance, and regulatory clarity, so residents, business owners, and communities understand what the law actually says, not just what headlines suggest. Today we are analyzing employer drug testing rights in February 2026. This is not HR advice. It is not industry lobbying. It is a legal interpretation discussion grounded in Virginia statutory law, enforcement practice, and developing employment risk exposure. We are focusing specifically on off-duty cannabis use, positive metabolite testing, safety-sensitive exceptions, wrongful termination exposure. We are not discussing how to consume cannabis. We are not encouraging workplace impairment. This is compliance-only legal analysis. And the reason this topic matters now is because enforcement and interpretation, not legalization alone, are driving liability. Here's the context. Virginia legalized adult-use cannabis under reforms passed by the Virginia General Assembly, modifying sections of the Code of Virginia related to possession and employment protections. Initially, employer discretion remained broad. Then amendments clarified employee protections regarding lawful off-duty conduct. So employers were left in a transitional gray area. The statute recognizes employer authority to prohibit impairment at work. But it does not automatically permit discipline based solely on past lawful consumption outside work hours. And that tension, between presence and impairment, is where policy confusion grew. This is also where enforcement diverges from assumption. Here's the legal explanation. Under Virginia law, cannabis is legal for adult possession within defined limits. That is the surface-level fact. But employment protections hinge on adverse action. An employer generally may not terminate solely because an employee engaged in lawful off-duty activity, unless an exception applies. Now, here's the complication. Standard drug tests detect metabolites. Metabolites show prior exposure. They do not reliably indicate real-time impairment. That matters legally. Because impairment during work is disciplinable. Off-duty presence is more complex. So when an employee tests positive on Monday for cannabis used Saturday, the lab confirms presence. But the employer must consider whether adverse action is tied to impairment or merely lawful off-duty use. And this is where most policies stop updating. We'll come back to how courts evaluate that. How enforcement works. Enforcement in employment cases does not begin with police. It begins with a complaint. An employee files a wrongful termination claim, or files through state labor mechanisms, or initiates civil litigation. And here's the key principle. The law says one thing. Enforcement says another. On paper, an employer can maintain drug-free standards. In litigation, the burden shifts to whether the termination was justified under statutory exceptions. Was the role safety sensitive? Was impairment documented? Was federal funding involved? Was testing required by federal law? Lab reports alone are not determinative. Courts examine documentation, supervisor observations, consistency of policy enforcement, and whether similarly situated employees were treated equally. This is where cases diverge. Who this affects? Consumers, meaning employees, are affected because lawful conduct outside work hours may now be protected in ways many do not realize. Retailers and private businesses are affected because blanket bans may conflict with statutory protections. Local governments in Norfolk and Hampton Roads must align municipal employment practices with state-level law. And within the medical cannabis framework, patients may have additional accommodation considerations layered on top of adult use reforms. Each category carries different compliance risks. But the unifying issue remains the same. Presence versus impairment. Now, this is the turning point. Because most employers believe they understand the rule. If someone tests positive, they're out. That feels straightforward. But this is where the law says one thing. Enforcement says another. You are allowed to prevent intoxication at work. You are allowed to protect safety. You are allowed to comply with federal mandates. But if your documentation does not distinguish between metabolite presence and on-duty impairment, that distinction, or rather, that failure to distinguish, can become the foundation of a wrongful termination claim. And that is where the financial consequence loop begins. Not criminal liability. Civil exposure. Litigation costs. Reputational risk. Why this matters? Public safety absolutely matters. No statute requires employers to tolerate impairment on duty. But regulatory clarity also matters. If employers misinterpret the statute, they create inconsistent enforcement. That leads to financial risk, employee morale risk, and long-term policy interpretation by courts that may further narrow employer discretion. Because once courts begin setting precedent, policy becomes case law. And case law shapes compliance expectations across the state. This is not about ideology. It is about risk calibration. Here's the scenario. Earlier I mentioned that a positive test may not equal lawful termination. Let's return to that. Scenario 1. An administrative employee in Norfolk tests positive after a random screening. No documented impairment. No safety-sensitive duties. No federal funding requirement. The employee consumed cannabis legally at home on Saturday. Termination occurs Monday. The employer cites zero-tolerance policy. Under current Virginia protections, that employee may argue termination was based solely on lawful off-duty conduct. Now contrast that with Scenario 2. A commercial vehicle operator in a federally regulated role tests positive. Federal Department of Transportation standards require drug testing. Impairment risk affects public safety. Termination aligns with federal compliance mandates. Same positive result. Different legal outcome. Because the small distinction, safety-sensitive status tied to federal regulation, changes everything. This is where that issue becomes clear. The silent question at the beginning. Can a positive test alone justify termination in 2026? The answer is, it depends on role, documentation, and statutory exception. Not just the lab report. And that is the legal reality. Here's what to watch next. Next, we examine how Virginia courts are likely to interpret the phrase lawful off-duty conduct when cases begin reaching appellate review. Because statutory language is only step 1. Judicial interpretation is step 2. And that is where long-term precedent forms. Here's a question to think about. If metabolite presence does not prove impairment, should employers invest in impairment detection training rather than expanding laboratory testing? Share your perspective in the comments. Let us know what Virginia cannabis law topic you want analyzed next. Like and subscribe for ongoing Virginia-specific legal updates. Join the Norfolk City cannabis community for deeper regulatory discussions. Because clarity matters. And in Virginia employment law, knowing the rule is not the same as avoiding the consequence.